A subpoena is an order from the court demanding that someone or something be provided to assist in a case. Lawyers who are licensed in the state usually have the power to issue a subpoena. However, individuals who are a party to a lawsuit and other individuals may also be able to issue a subpoena, depending on the rules of civil or criminal procedure in the court that has jurisdiction of the case. Reasons for a subpoena. In some cases, an individual who is party to a lawsuit may desire to have someone present at court. This individual may have crucial information or be an eyewitness. For example, a school principal may be subpoenaed in a family law case, or a witness may be subpoenaed in a case involving a motor vehicle accident. A subpoena requiring court testimony is called a subpoena ad testificandum. This type of subpoena may also be used to compel someone to appear at a deposition. Individuals may require subpoenas in order to justify missing work to their employer, or because they do not willfully want to involve themselves in the proceedings. A subpoena can also be issued if a party wants a person or organization to provide him or her with certain documents or physical evidence. This type of subpoena is called a subpoena duces tecum. This may be necessary when an individual wants a police department to provide a copy of a police report or other documents. It may also be necessary to acquire certain medical, financial or school records for other cases. This subpoena requires the person who is the custodian of the records to provide them to the party within a certain period of time. Party acquisition. A party to the lawsuit, whether the plaintiff or the defendant, can usually ask for a subpoena. He or she typically has to complete a subpoena form that includes the witness name and address. If it is a subpoena duces tecum, the party must describe the items that he or she is requesting in sufficient detail so that the individual knows what is being asked of him or her. The party must usually declare under penalty of perjury that the information included in the form is true and correct to the best of his or her knowledge and belief. It usually must be notarized. This subpoena must be signed by the judge who is presiding over the pending case. Other issuers. In some states, a court clerk has the power to issue a subpoena. A justice of the peace or a notary public may also be able to issue a subpoena. This varies by jurisdiction. Procedural requirements. After the party acquires the subpoena form, he or she must comply with several procedural requirements. These requirements vary by jurisdiction. State rules on civil procedure are different than federal rules of procedure. The party who is requesting the subpoena must usually provide a copy to the court clerk. Some court clerks submit subpoenas to the sheriff directly, while others may leave service to the party requesting the subpoena. Some states require a subpoena to be accompanied with a payment for the witness administrative expenses, travel expenses or appearance. Others allow the witness to request such fees. If the court clerk does not take care of service requirements, the party who is sending the subpoena must serve the witness in accordance with the applicable rules. The rules for a lawyer serving a subpoena may be different than the rules for a party who is appearing pro se, without a lawyer. Service may be valid if it is by certified mail, delivery restricted or served in person, depending on state rules. After the person is served, a certificate of service or similar document must be completed that states that the individual was served, circumstances involving service, and any other information as required by state law. Complications. Although it may technically be possible to get a subpoena without a lawyer, doing so carries with it certain risks. For example, if the proper person is not named, the party may not receive the documents that he or she is requesting. The subpoena must be listed in the person's name who actually has the records. An individual who is served with a subpoena may hire his or her own attorney. Through a motion to quash, the individual may be able to avoid having to appear in court or provide documents if the subpoena was not processed or served correctly, or if the individual has another legitimate reason. COPWATCH.org